Good evening to the participants of the JCJ Andhra Pradesh as well as the Telangana State 2023 Karibu Sana in Kiswahili. Welcome to my virtual class. And without wasting the time, let me go to the shooting purpose. Yes. Now let me close it. Then we can scroll up. Yes, where is the scrolling? Yeah. Yes, be ready to shoot. The first question. The Limitation Act contains dash sections and dash articles and the dash are divided into the parts. How many sections, how many articles and how many parts are there? A. 30, 137, 11. B. 31, 137, 12. C. 32, 137, 10. D. 31, 137, 11. Shoot.
Option D, sir.
Option
D.
Delhi. D for Delhi.
Yes, sir.
WRONG.
Option B, sir. B for boy. 31, 137, 12.
WRONG.
C.
C is the CAT cat. 32 sections and 137 articles and 10 parts. Is it?
But section 32 is repealed, sir. Omitted, I think.
Okay. No, not 32. It is a repeal, but in the count we will say 32. Of course, we do have what are the sections are repealed. And when you see it, no, but parts are 5 only I found, but I don't know from where the other 10 has come.
No, sir. 10 parts are there. I checked it.
When I see this is the Bare Act. See part 5,
Yes, sir.
miscellaneous, and 32 and 28 is repealed. That we covered in the thing, but I don't know. When I checked it, I found 10, but I don't know what is wrong. But 137 articles are there and 32 sections are there. Yes?
Sir, actually, in third division, part 1, part 2 additional is there, which includes Article 137.
Okay.
That may be listed here.
Yeah, that is still I found because I checked it articles here. Now I will show you the articles later. Okay, now let us see that. So the right answer is one I can say 32 is the right, 137 is the right, but the parts I doubt. Anyway, that subject to the correction, two things are correct. Is it clear?
Yes.
Now the second
Yes, sir.
question. Just do you want to say anything? Shall I continue?
Yes, sir.
Yes, sir.
Second question. The Limitation Act is dash with respect to all matters expressly dealt in it. It can't be extended by analogy. A. Not exhaustive. B. Inexhaustive. C. Exhaustive. D. Unexhaustive.
C, exhaustive.
C is the right answer. Exhaustive it is. Now the question, third question. In dash, the Punjab and Haryana High Court ruled that it is well settled law that the law of limitation is a procedural law and operates retrospectively unless it has been provided differently in the amending statutes. A. Venkateshwara Chemical Limited versus Union of India and others. B. State of Punjab and others versus MS Dauba Cooperative Sugar. And C. Excise and Taxation versus Mr. Frigo Glass India Private Limited. D. Balaji Chemicals Limited versus Union of India and others.
Option B.
WRONG. Second option.
D,
It is
D.
C, excise and taxation versus Mrs. Frigo Glass India Private Limited. It is decided in that manner. So, fourth question. The law of limitation finds its roots in the maxim A. Intereste republicae ut fit finis litium. B. Intereste republicae at lit finis litium. And C. Intereste republicae ut bit finis litium. D. Intereste republicae ut sit finis litium.
D.
Yes?
D, sir. D for dog.
WRONG. Second option.
B, B.
Yes, it is the intereste republicae ut lit finis litium. That is the right answer. So that is based on it because it gives the sense one cannot wait for that longer time. That is the meaning of it. But anyway, the another maxim let's see. It means that in the interest of the state as a whole, there should be a limit to the litigation. That is the meaning of it. Dash, which means the law will assist only those who are vigilant with their rights and not those who sleep on it. It's another maxim is there. And that maxim says like this. A. Vigilantibus non dormitibus jura subveniunt. And B. Vigilantibus non dormitibus jura subveniunt. C. Vigilantibus non dormitibus jura subveniunt. D. Vigilantibus non dormitibus jura subvenient. Now, ABCD. Among the ABCD, which one is the right maxim? The equivalent is the law will assist only those who are vigilant with their rights and not those who sleep upon it.
C, sir.
Option B, sir.
B for Bombay.
Yes, sir.
WRONG.
C, C.
C for cat.
Yes, sir.
WRONG.
D, D. Vigilant.
D for the dog or Delhi.
Yes, sir.
WRONG.
Option A, sir.
A is America. Vigilantibus non dormentibus jura subveniunt. That is the Latin maxim, and which equivalent is the law will assist only those who are vigilant with their rights and not those who sleep upon it. So the two maxims the Law of Limitation Act based. One is this maxim, another is intereste republicae ut fit finis litium. That is another maxim. That is means the interest of the state as a whole, there should be a limit to litigation. That means. Okay, now let us go to the sixth question. The law of limitation specifies the statutory time frame within which a person may dash legal proceedings or legal action can be brought. A. Start. B. Begins. C. Initiate. D. Move.
C, initiate.
C is the right answer. Initiate is the right answer. Not start because the legal terminology, right legal terminology, it may initiate the legal proceeding or legal action can be brought. Now the seventh question. The court in dash ruled that it is a well settled proposition that even a void orders have to be challenged so that the same can be declared as void. Even a void order continues to have effect till the same is declared non-est. A. Surat Singh and others versus IFCI Limited and others. B. Jugal Kishore Somani and other versus Banwari Sanva of Bhagirath. C. Ram Singh versus Gaushala Patiala and others. D. Devi Swarup versus Srimati Veena Nirvani.
Option A, sir.
Surat Singh.
Yes.
WRONG.
Option B, sir. Devi Swarup versus Srimati Veena Nirvani.
Option D is the right answer. Devi Swarmu versus Srimati Veera Nirvani. That is the right answer for the above 7th question. Now let us go to the 8th question. And the Limitation Act was subsequently repealed in the year dash. The Limitation Act of 1908 was repealed by the Third Law Commission and Limitation Act of 1963 came into force. 1. 1871, 2. 1877, 3. 1903, 4. 1908. Now, options A, 1 plus 2 plus 3, and B, 1 plus 2 plus 4, and D, 2 plus 3 plus 4.
Yes, sir.
A is the right answer. No. Wrong.
Option B, sir. 1 plus 2
Option
plus
B is the
4.
right answer. It is 1, 2, 4. Means 1871, 1877, 1908. I put it 1903. That was repealed. The Limitation Act was subsequently repealed in the year 1971, 1877 and 1908. The Limitation Act of 1908 was repealed by the Third Law Commission. That is the Limitation Act of 1963. What is the present act number?
1963.
1963, sir.
Act number? What is the act
36,
number?
sir.
Supplementary
Act
question.
number 36, sir.
Okay. 9th question. The Supreme Court in dash held that the rules of limitations are not meant to destroy the right of the parties. Section 3 only bars the remedy but does not destroy the right to which the remedy relate to. A. Punjab National Bank and other versus Surendra Prasad Sinha. B. Krishna Rao Keshav versus State of UP and others. C. Azim H. Premji versus State of Chhattisgarh. D. Avdesh Mittal versus Standard Chartered Bank.
Yes, sir.
You are right. It is A is the right answer. Punjab National and others versus Surinder Pratap Sinha is the right answer for the 9th question. Now the 10th question. Anyone can unmute and read?
The dash
The
act
dash.
referred only to foreign contracts, whereas the 1963 Act talked about contracts entered into the territory of Jammu and Kashmir or in a foreign country.
It is
Option A,
not nicely
1837.
audible. Keep the gadget very near to your mouth. Resound is coming.
Actually, I
Lavan-
have network issue, sir.
Yeah, resound is coming. Lavanya, you read it.
The Dash Act referred only to foreign contracts, whereas the 1963 Act talked about contracts entered into the territory of Jammu and Kashmir or in a foreign country. Option A 1877, option B 1891, option C 1908, option D 1963.
Shoot.
C.
Yes, it is a C. 1908 is the right answer. Now the 11th question. In the case of dash, the court held that a defendant in a suit can put forward any defense, though such defense may not be enforceable in the court for being barred by limitation. A. Collector LA versus Katiji, and B. Devi Swarup versus Srimati Veena Nirvani. C. Against the judgment in as 15 virgule 1996 versus KJ Anthony. D. State of Punjab and other versus Gurudev Singh.
D, sir.
Option D, sir.
D.
Read full.
State of Punjab and others versus Gurudev Singh.
WRONG. Second option.
C. Against the judgment.
Against the judgment in as 15 virgule 1996 versus KJ Anthony is the right answer. Further, in the case of the court held that defendant in a suit can put forward any defense, though such a defense may not be enforceable in a court for being barred by the limitation. 12th question. The most important provision of the act relating to the bar of the limitation occurs immediately thereafter in dash. Dismissal of the suit, appeal, or application tied tiled after the prescribed period is mandatory. Section 2A, option B, Section 3, option C, Section 4, option D, Section 5.
Option D, sir. Section 5.
5.
WRONG.
Section 2, sir.
It is a very important section in the law of limitation.
Section 2, sir.
Wrong.
3 says.
Section 3, if you happen to
3.
see Section 3, it shows that bar of limitation. It is only the one section which is the heart and soul of the Limitation Act. Is it clear?
Yes.
It is only the section where all the cases would be filed, and most of the cases would be filed. That's why you can say heart and soul of the section. What is the heart and soul of the Constitution?
Preamble, sir.
No. What is the heart and soul of the Constitution? No idea. No, let me clear because I know it, but I also don't. Heart. Article 32. Let me see. Heart and soul of the Constitution as per Dr. Ambedkar. According to the architect of the Indian Constitution, Dr. Ambedkar, the right to constitutional remedy is known as the heart and soul of the Constitution. Constitutional remedies. What is that article? What is the heart and soul of the Constitution of Dr. Ambedkar? Article 30.
Article 30.
I also committed a mistake. 32 is the writs, 26 and 32, but it is the remedies available in the Article 30. It is a very important factor. Okay, now let us come to the heart and soul of the Limitation Act is Section 3.
3.
Okay, now let us go to the next section. The Supreme Court in Dash observed that statutes of limitations are retrospective effect so far as they apply to all the legal proceedings brought after their operation for enforcing the cause of action accrued earlier. A. Tirumala Chemical Limited versus Union of India, Tirumalai Chemical Limited versus Union of India, Tirumalai Chemical Limited versus Union of India, and Tirumalali Chemical Limited versus Union of India. I made only the spelling change.
A. Tirumala Chemicals Limited versus Union of India.
WRONG. It is the B. Tirumalai. Thirumalai. Chemical Limited versus Union of India. B for Bombay is the right answer. Tirumalai. Okay, now 14th question. Unmute and read with the sound. Sonorous voice.
Time period for various suits has been provided in dash of the Act. Option A table, option B section 43 to 53, option C schedule, option D part 4. Option C schedule.
Option
C
C
schedule is the right. There is no section 43. At least you should reduce it 23 to 28. Okay. Now, so schedule is the right answer actually. Okay. 15th question, I will read it. Which statement is wrong among the four? A. The very crux having the limitation law in force is the person cannot sleep over his right for an indefinite period and seek such a remedy as a later stage. B. The being the tenets on which the law is based, there are several basic principles which the law states. C. The principle substantially affect the right of the parties. D. Recently there has been a lot of commotions around the banner and the circumstances in which the limitation law can be invoked in the context of the Insolvency and Bankruptcy Code 2016, though it is established now that the limitation law is applicable to the proceedings under the code by virtue of the section 238. Which statement is wrong among the four?
C. C.
Means these principles substantially affect the right of the parties?
Yes, sir.
It's the right. It's not wrong. Because one of the party is the loser, even though he is supposed to claim it, but he did not claim it because law of limitations barred the remedy, but not the right. Even the court suo motu can also bar when the limitation period crosses. It is a difficult task. We cannot make it out.
B, sir.
Yeah, it is a difficult task.
B.
What is?
B. B for ball.
No.
D.
It is actually 238 capital A. I removed the capital A and I put only 238. That's why I told you, it's difficult for you. There has been a lot of commotions, and what they say is limitation law is applicable to the proceedings under the code by virtue of the section 238 capital A. That is the feedback for this one. Now, 16th question. Such questions may not ask, but there may be possibility. There may be. So, 16th question, which statement is the correct statement among the four options? And A, for debt recovery, the statutes of limitation is 3 years from the day the money was borrowed. Suppose there is no disputes regarding the money lent within 3 years of lending it. In that case, the state of limitation expires and the court has a very right to refuse to entertain the case. B, for the debt recovery of the statutes of the limitation is 3 years from the day the money was lent. Suppose there is no dispute regarding the money lent within 3 years of the lending it. In that case, the statute of limitation perishes and the court has every right to refuse to entertain the case. C, for the debt recovery, the statute of the limitation is 3 years from the day the money was lent. Suppose there is no dispute regarding the money lent within the 3 years of lending it. In that case, the statute of limitation expires and the court has every right to refuse to entertain the case. D, the debt recovery, the statute of limitation is 3 years from the day the money was lent. Suppose there is no dispute regarding the money lent within the 3 years of the lending it. In that case, the statute of limitation expires and the court has every right to refuse to entertain the case. I made a little differences here and there. But which statement among the A, B, C, D is the right?
C.
Shoot.
C, sir.
I don't know whether you are saying C or whether you are saying D.
C for cat.
Like that you have to say. C for cat. WRONG. If you closely observe it, you could know the difference. Say the full.
D.
B for bat,
for
B for
dog.
Bombay, D for Delhi,
D for
A for America,
D for Delhi.
WRONG. B for Bombay is the right. For a debt recovery, the statute of limitation is 3 years from the day the money was lent. Suppose there is no dispute regarding the money lent. Within 3 years of the lending it. In that case, the statute of limitation perishes and is it perishes? No, expires.
Sir, it is not perishes,
Not.
expires.
C is the right answer. C is the right answer.
Sir, C
C is the right answer. Answer C is the right answer, not perishes. Is it clear?
Yes, sir.
So it is not the perishes. Yeah, C is the right answer. No change is made in the correct answer is C. The 17th question. It was held that it was held in dash. The bar of limitation does not stand in the way defense. It only bars the action. It is only its recovery that is time barred. There is no provision that prohibits or prevents a debtor from clearing him time barred outstanding. A. Mrs. Varinder Kumar Surinder Mohan versus Gur Darshan Singh and others. And B. Rulia Ram Hakim Rai versus Fateh Singh. C. Nathulal versus Vishnu Chand. D. Srimati Mankumwar Bai and others versus Sundarlal Jain.
Yes, sir.
WRONG.
C.
Nathulal versus Vishnu Chand.
Yes.
WRONG. The right answer is Rulia Ram Hakim Rai versus Fateh Singh. B for Bombay. Now 18th question. As per the Reserve Bank of India, you can indefinitely retain foreign exchange up to the US dollars, in the form of the foreign currency note or traveler check TCS for future use. A. 2000, B. 3000, C. 5000, D. 10,000. I said indefinitely retain. I did not say how many US dollars you can bring into India.
C. 5,000.
WRONG. It's a difficult a bit, but don't worry. 2000. A. 2000 you can keep it written indefinitely. But when you are bringing, of course they say unlimited, but they put the condition. But they have to make the declaration at the immigration. Now we do have another case law now. Another question having such a nature. Yes, the Bombay High Court in Dash observed that the true guide for the court while exercising the jurisdiction under Section 5 is whether the litigant acted within the sensible and reasonable diligence in the prosecuting the appeal. A. Bridge Indar Singh versus Kansiram. B. Mahangu Vishwanath Haske versus Bhagirat Boy Shravan Hasko. And C. Jokaram Reddy and other versus Gokar Malaya. D. Rangubai Kom Shankar Jagdap versus Sundarbai Bharattar Sakharam.
B for ball.
WRONG.
Yes, sir.
America A. Bridge Inder Singh versus Kanshiram. That is the right answer. A is the right answer. America A for America is a Bridge Inder Singh versus Kanshiram is the right answer. 28th question. In debt, a crime in India. A. Civil. B. Criminal. C. Both civil and criminal. D. All of the above.
A. Civil.
How could you say A. Civil? Suppose if you don't give the money, run away. Or you give the check.
Sir.
There is insufficient fund is there.
Option D, sir.
Option D is the right answer. All of the above is the right answer. You cannot run away. It's a crime. So right answer is D. So 21st question, in dash, the Supreme Court clarified that since the law of limitation is procedural in nature, it will be applied retrospectively. A. Sabarmati Gas Limited versus Shah Alai Limited. B. BK Education Service Private Limited versus Parag Gupta and Associates. C. Ishrat Ali versus Cosmos Cooperative Bank Limited and another. D. Anubhav Anil Kumar Agrawal versus Bank of India and another.
A, sir.
WRONG. The answer is B. B for Bombay. BK Education Service Private Limited versus Parag Gupta and Associates. It was decided in that manner. Okay, 22nd question. Article 124 of the Limitation Act 1963 provides a limitation period of the 30 days for seeking the review of the judgment passed by any court other than the dash. A. First class judicial magistrate court. B. District court. C. High court. D. Supreme Court.
Option A, sir.
A.
WRONG.
D, sir.
It is a D for Delhi. Supreme Court is the right answer. I want to keep the Zawadi for that one, but just Chaka, I am in the online class now. I will call you later. Okay, now next question is 33rd question. In dash, the court held that even for a void orders, if the suit is filed, then the period of limitation prescribed by the schedule appended to the Limitation Act is applicable. A. Manke Ram versus State of Haryana. B. Sukhdev Raj versus State of Punjab. C. Devi Swaroop versus Srimati Veena Nirvani. D. Ramcharan Singh versus State of Rajasthan.
Sir, you are not properly audible, sir.
Yes. 23rd question. In dash, the court held that even for the void orders, if the suit is filed, then the period of limitation is prescribed by the schedule appended to the Limitation Act is applicable. A. Manke Ram versus State of Haryana. B. Sukhdev Raj versus State of Punjab. And C. Devi Swaroop versus Srimati Veena Nirvani. D. Ramcharan Singh versus State of Rajasthan. Is it audible?
Yes, sir.
Yes, sir.
Shoot.
B, sir. B for box.
You're right. Sukhdev Raj versus State of Punjab is the right answer. Now the 24th question. The principle which forms the basis of this rule is expressed in the maxim, the law give help to those who are watchful, not those who sleep. I think I repeated. Okay, now you tell me A, B, C, D, which is the right answer. This
D,
is a
sir.
repetition. This is the
D.
repetition, I said. Sir, we don't know.
D for Delhi.
Sir, all are same, sir.
WRONG. This is the
Sir, all are
repetition. The right answer is C. Vigilantibus, non-dermentibus, jura subvenient. C. C for cat. Now the 25th question. Article 126 of the Limitation Act provides dash years as the period of limitation for a dash that is more than years after the date of the taking the position of the alliance prima facie barred by the limitation under the Article 126. What are the two dashes? 1121, B 1212, C 1221, or D 1321.
C. C, sir.
C is the right answer. You are right. 12 and 21 is the right answer. Now, how many sections are repealed under the Limitation Act? Already we discussed. How many? 2. B is the answer. And what are they? We already told. What are they?
32, sir.
32 and
I've shown also.
28.
I've
32 and
shown that.
28.
Yes?
32 and 28.
32 and 28. When you know one answer, automatically you know the another answer. 28. Match the following part A and a corresponding heading in the part B. Part 2, part 3, part 4, part 5. B. A. Acquisition of the ownership position. B. Miscellaneous. C. Limitation of the suits, appeals and application. D. Computation period of the limitation. A. 1B, 2C, 3D, 4A. And B. 1C, 2D, 3B, 4A. C. 1C, 2D, 3A, 4B. D. 1A, 2D, 3B, 4C.
C. C. C.
I already
1C,
shown.
2D, 3D.
Wrong. Right. C is the right. Because I already shown some of them. Part 2 already shown. Then it's everybody knows miscellaneous is the last chapter. Am I right?
Yes. Yes.
Yes. Now, in which part there are less number of sections in the Indian Limitation Act? In which part?
Part 4, sir. Sir,
Wrong.
part 1. Part 1.
Part 1.
Yes, sir.
I don't know why, because I have already shown here when I was making the things shown to you. I don't know why you did not get it. Because I have shown here when I was making like here. Okay, now here this is the, I give 100. Zawadi to you, last question. Limitation only in the sections. How many times it is repeated? I say section, skeleton, not here, not here, not in this one. Limitation, how many times it is used over there? Okay, I can give the option. 3, 4, 5, 6.
5.
Right. I will give you the Zawadi to you, Lavanya. It is the 5 times. Number 1, 2, 3, 4, and 5. Only 5 times. So Lavanya is entitled for the Zawadi 100 rupees. You will get it your Google Pay or Phone Pay now. Only 5 times it is used over there in the limitation. Okay, with this, I would like to wind up my today's class and let us meet again. Timetable, if you happen to see, where is the timetable? Yes, it is here. Yes, tomorrow, next is 1st, is it not? 1st April. April Fool banaya. No April Fool. It is the truth. If you make a practical joke, it is also an offense. Which case law says? Anyone? If you make a practical joke also, it is an offense. You will be fined.
उच्छल जलधि तरंग
तव शुभ नाम जागे तब शुभ आशीष मांगे गाहे तव जय गाथा
जन गण मंगलदायक जय हे
भारत भाग्य विधाता
जय हे जय हे जय हे जय जय
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
ख्वाब तो सिर्फ कश्मीर की आज़ादी के आते हैं।